Hi, I'm Gareth. I'm from Pinpoint Lawyers and I specialise in dispute resolution, particularly in commercial law. So I help business owners and individuals sleep better at night and get back to what they would much prefer to be doing rather than being buried in litigation. So I wanted to do this video in order to explain something that's of great importance to almost all of the clients who speak to me for the first time, because they want to know what costs can I recover in the court claim I'm about to go into. And that's whether they're on the claimant side or the defendant side. I deal with both. And the answer, as with much of legal questions, is it depends. And what it depends on largely is the value of the claim and therefore which track it falls onto. So I'm going to spend a little bit of time on this video dealing with the 4 individual tracks that the courts of England and Wales deal with, which is where any claim that you might be involved in will end up falling onto. And that's the multi-track, the intermediate track, the fast track, and the small claims track, often referred to as the small claims court. Before I get into that, I just wanted to tell you a little bit about what I do. As I said, I specialise in dispute resolution. That is the whole range of coming to me and saying, I'm owed money by another business, help me to get it back. Or this business says that we've breached the contract in this way. Businesses come to me with their problems and I do my very best to solve them. I tend to be pretty successful. What success means in a given context very much depends on 3, 2, 1. I fix the problems that businesses come into in their day-to-day running. I like long-term strategic thinking. Clients tend to like that because they get a clear roadmap of we are starting here and we will end up there. And they know all of the options, from what are the potential outcomes, what are the likely outcomes, the worst outcome, what's the likelihood of that happening to me? That's a big question a lot of people ask. And I pride myself on being as no nonsense as any lawyer. I want you to have the unvarnished truth so that you can make the best decisions for your business. Now, if that is of interest to you, go to our website, pinpointlawyers.com, fill in the form, give us a little bit of information. We are offering a service where the first step is always a review of the documentation, a conversation probably of 60 to 90 minutes. I prefer Microsoft Teams to do it by video rather than over the telephone. I can do it anywhere you're based in the country, no problem at all. And we talk about what your needs are as a business. We talk about what your preferred outcomes are. We get the information, the strengths and weaknesses that you're aware of, so that I can go away and give advice as to whether you're likely to succeed in your claim or defence, what the pitfalls are, what the likely costs are, which is very much on the point of this video, and where we go next from there. That fee for that work tends to be in the region of £2,000 plus VAT. It is amongst the best value work that I offer, because for the first time my clients learn where they're going with the dispute that they're in. Quite often people come to me and they're in a little bit of a panic, either because they are being kept out of some money that they know they're entitled to but don't know how to get it, or someone's accused them of something that they don't know how to defend it. And I'm able to be a calming influence. I can direct the ship and say, look, this is where we're heading. And once you know where you're heading, everything becomes a lot more comfortable, a lot clearer, and you can start to plan for the future, not only within the litigation, but also for the remainder of your business. So if that's going to be useful to you, pinpointlawyers.com. But coming back now to the question of what costs can I recover if I end up in a court claim in England and Wales. Now, starting at the top of the spectrum I just talked about, multi-track. Multi-track cases are the majority of what I deal with. That's in excess of £100,000. So if your claim is worth more than £100,000, it will most likely go into the multi-track. And I'll be happy to deal with that for you. And the good thing is you are more likely to get a greater proportion of your costs back on the multi-track than you are on any other. Now, the reason for that is the costs regime in court claims in England and Wales works off what's known as the indemnity principle. You will never be able to recover on the multi-track more than you have spent in your legal costs. But that does not mean that you will get back your full amount of legal costs if you succeed in your claim or defence. That is subject to a couple of things. Firstly, it is subject to a cost budget. So you will have a cost budget after you've started the claim or after you've put in your defence, but well before things like experts or witness statements are involved. And the cost budget will be you saying, or more accurately, your lawyer, this is what it will cost in legal fees to get to the end of trial. And it goes stage by stage. There's 12 or 13 stages off the top of my head in a form called Precedent H. If you want to have a look at it, Google Precedent H. And what will happen is each side will look at the other sides, and a judge will look at both sides and say, this looks reasonable at this stage, but that looks a bit unreasonable. Can you explain why you've said you need that much budget for that particular stage? And the budgets will be worked through, and eventually the judge will say, oh, your cost budget is fixed at X amount of money. And that will be your cap on what you can recover at the end of a successful claim or a successful defence. But it's still not the amount that you will actually get to recover, because that is assessed at the end of a claim, at the end of a successful defence. Whoever wins generally gets a costs order in their favour, and the court then needs to decide whether the amount of costs was reasonably incurred and reasonable in amount. Now, as a rule of thumb, most lawyers will say to you, the most amount of costs you will recover is about 2/3. Now, there's a reason for that, and the reason is that a lot of lawyers are inefficient, therefore they charge on an hourly rate, they spend too much time on things, and the court says that's too much time. A second reason is that hourly rates are often charged out at more than the court will order. The court has some guideline hourly rates. There's different ones for London, different ones for across the country, depending on where the lawyers are based. And so you will recover a greater hourly rate for a London lawyer than you would for someone based in, I don't know, Birmingham, Ipswich, anywhere like that. Now, how can you deal with that in order to make yourself more likely to recover as close to the full amount of legal costs that you've expended as possible? I think that the best way to deal with that is to work with a lawyer that provides fixed price litigation. I'm pleased to say that that's what I offer. The reason that I offer it is transparency at each stage, certainty at each stage, and keeping those costs proportionate to what's at stake. Because I know with my experience over the past decade, roughly how long something's going to take, roughly how complex it will be, roughly the value that you're going to get out of it. I'm good at estimating all of those things. And on that basis, I'll say for this stage of the proceedings, let's say it's starting the claim, I will do this work for a fixed price of X. And you could go ahead and say, yes, Gareth, I want you to do that. And that way, if it takes me twice as long as I thought it was going to, that's on me. You don't have to pay more just because I misunderstood something or something's a bit more complex than I thought. My assessment at the start will guide the fixed price. For that stage, you can agree it, and then you've got peace of mind that you can get on with it and you're not going to go out of budget. I offer that, a handful of other lawyers do. Most lawyers don't, and I don't understand why, because it's far better for clients, and frankly, it's better for law firms too. But anyway, so you are more likely to recover a higher amount of costs on the multi-track, which means that you can afford to spend a bit more, subject to having the cash on hand to pay it in the first place. You can afford to spend a bit more on your legal costs. That makes sense because you've probably got more at stake as well. If it's on the multi-track, it's greater than £100,000, you've probably got more at stake than you would do in the other tracks. So that's the multi-track. Now, if your claim is worth less than £100,000, the first track below there is the intermediate track, which is between £25,000 and £100,000 in value. And that is subject to a fixed recoverable costs regime, which is provided for by the civil procedure rules. I'm not going to go into the figures because, frankly, it's unnecessary. But what I can say is there are 4 stages of complexity for a claim on the intermediate track. The more complex the court deems the claim to be, the more cost you can recover, because in theory, the more effort and work and time will need to be expended by a lawyer like me. Now, what does that mean for you in practical terms? It means there is an absolute cap on how much you can recover in terms of your legal costs on the intermediate track. If you exceed that cap, you can get the additional amount back. So, for example, if the cap was £50,000 plus VAT, I wish it was as round as that, it never is as round as that, but you spend £60,000, you will not get £60,000 back under any circumstances. The maximum you'll get is £50,000. However, if you spend £30,000 and the cap is £50,000, under the fixed recoverable cost regime, the indemnity principle that I just talked about doesn't apply, and therefore you can actually recover that £50,000 up to that cap. So you could spend £30,000 on your legal fees, but actually recover £20,000 on top of that. Worth bearing in mind, because as a lawyer who deals in fixed prices, I always try and come in under that maximum cap, whatever that is. I generally tend to achieve it. I can't guarantee it on your case, we've not spoken yet, but I will be able to give you a good idea on our initial call, do I think that I can come in within that cap? And that's great for you because you can budget properly knowing the most I will spend on my legal costs here is X amount of money, and it's likely that I can recover it from the other side if I succeed. And that might give you the green light to go ahead. So we can have a conversation about that. Now, below that is the fast track, and this is where it starts getting a little bit sticky in terms of being able to afford lawyers who can do the job properly. Generally, you will find that if you instructed someone with my experience, my expertise, that I would end up charging more than you could recover under the fast track costs rules. Because again, it's fixed costs. The fast track deals with £10,000 to £25,000 in value. So if your claim falls there, you're going to be on the cusp of whether you can afford a lawyer that can do this properly. Off the top of my head, the fast track, the fixed recoverable costs at maximum are in the range of about £5,000 plus VAT. You're probably going to spend that on a combination of getting the claim started and the trial itself. But you've still got that middle chunk, which is still a lot of work, witness statements, expert reports, the disclosure process, things like that, which are going to need time and money spent on, and you probably won't recover all of your cost for that. I try, on the odd occasion that people come to me and ask me to deal with fast track claims, I have tried to keep it within those bounds before. It's very challenging. The value that I provide and the price commands, frankly, tends to exceed the amount that the court will allow you to recover. The question is then, why does the court have it that way? Don't ask me. Ask your MP, but it's been successive governments who haven't really fixed that. So on the fast track, have a conversation with a lawyer, try and agree fixed prices. Bear in mind that you are going to be less likely to recover your full amount of costs. You need to factor that into your strategy when it comes to a fast track claim, because you're going to want to reach an economical outcome sooner rather than later, whether that's offering more than you wanted to offer in order to settle the claim, accepting less than you wanted to accept in order to settle a claim. Some cases, they become almost existential in that you almost have to win it in order to consider yourself to have had a successful outcome at all. In that case, you may have to spend more than you can recover on costs. That's a discussion to have at an early stage with a lawyer. Again, it's the sort of thing that I'm able to advise on that initial piece of work that I do. That's substantial advice, but speak to a lawyer about that strategy. Then, right at the bottom, we've got the small claims track. Often called the small claims court. It's not a different court. You haven't got sort of Judge Rinder over here dealing with the small claims and everything else being dealt with in the county court. It's part of the county court. But more importantly, when it comes to what cost you can recover on the small claim track, the headline is not very much at all. And it's probably not going to be worth you instructing a lawyer if your case is only about money, because whatever you get back will probably be swallowed up. The costs you can recover are the court fees, expert report fees, if you actually have an expert on the small claims track. The fact that you have an expert on the small claims track makes it more likely you actually end up on the fast track, which means that you wouldn't be considering that anyway. But it's court fees, expert report costs, and witness expenses. That's it. Now, there is an exception, and I have to stress it is an exception. There's part of the civil procedure rules that says the court may order that the other side pay the winning party's costs or another party's costs. It's not just the winners. Another party's costs if that party has behaved or conducted themselves unreasonably in the litigation. Now, I'm often asked by clients, well, rely on that. Of course they've been unreasonable. They denied the claim. They've been found to have lost. That's not unreasonable conduct. Unreasonable conduct might be, for example, the one time I succeeded on an argument for getting costs for unreasonable conduct was when the other side brought a claim, then didn't bother putting any evidence, then didn't bother attending the trial, which meant that my client had to go to the cost of attending the trial and making sure that the claim was dismissed. On that one occasion, and it is the only occasion in 10 years of dealing with litigation, that I've been able to get the court to award costs on the small claims track. Now, the one time when you may consider it to be worthwhile paying a lawyer to do your litigation on the small claims track is if it's something that's really important to you but doesn't carry monetary value, such as a boundary dispute, a neighbour dispute. Those sometimes do fall on the small claims track because the value is minimal, but it's, for example, someone not allowing you the right of way down the back of a row of houses, or somebody sort of building a fence on your land after knocking it down when it was on the boundary. That sort of thing. Because that's of such importance, you may have to come to terms with the fact that it's so important to you that you can't let it go, or at least that you can't negotiate over it to a reasonable settlement, but it's not something you can avoid spending money on, and you have to come to terms with the fact that you will not recover those costs. Again, something to bear in mind with an initial conversation with a lawyer. So there we have it. That's what you are likely to recover in terms of your costs if you go into litigation, if you either start a claim or have to defend a claim. Multi-track, you can recover a greater amount of costs, still subject to the indemnity principle, which means you only get back anything that you've actually spent. Rule of thumb is 2/3, but you've got a better chance of recovering more if you're able to fix your fees with somebody like me, because the court's less likely to say, oh, well, you've gone in at a too high an hourly rate or you spent too much time on it. Time isn't the factor there. Intermediate track, you've got those fixed costs that you can recover, and quite often if you use Pinpoint Lawyers, you'll be spending costs that fall within that cap anyway, and therefore you've got certainty, you've got a level of protection there that costs aren't going to get out of hand, and if you succeed, the court will say, okay, you reached this stage, it was a case of this complexity, the exact amount of costs you can get is prescribed in law, therefore you will get this. And you've got a good deal of certainty there. Fast track, you're starting to nudge into the territory where you're not going to get a large amount of costs back, and therefore you need to think carefully about what you're spending. You need to be cost effective. And then on the small claims track, you're unlikely to get any costs back at all. So I hope that was helpful. You can subscribe if you are interested in getting more legal tips and more insight into not only the litigation process, but also issues that come up in commercial law, matters to do with running a company. There's going to be plenty of videos from Pinpoint Lawyers about all of those things. And in fact, in due course, we're going to expand into different areas of law. So you can subscribe and share this with someone else if you think it will be useful to them. If there's something else you'd like to know about in terms of commercial law, please leave a message in the comments and I'll review it, and maybe I'll do a video on that in the future. But if you need help from me in particular, I'd love to hear from you. Come over to pinpointlawyers.com. Send your inquiry over and someone will be in touch very soon.